Hello and welcome. My name is Stephanie, and in this video, I'll be breaking down what the Individuals with Disabilities Education Act, Part B, says in regards to Individualized Education Plans, or IEP. My goal with these videos is to equip parents with relevant information about their rights and their children's rights so that they may become better advocates for their children in the IEP process. So let's jump straight in with what is an IEP. Again, it stands for Individualized Education Plan. Part B defines IEP as a written statement for each child with a disability that is developed, reviewed, and revised regularly. It should include a statement of present levels of academic achievement and functional performance. Basically, the statement reflects how the child is doing with what is currently in place, if anything. The IEP will also include a statement describing how the child's disability affects their participation and performance in general education to really help define what supports and services the child may need going forward. Additionally, it'll include a section of academic and functional goals that must be measurable, and the goals will relate directly to those needs that were identified. The IEP has to define how and when progress on the goals will be monitored and reported. As a parent, you do have a right to these progress reports. So if it helps you to set reminders in your phone or on a calendar, please do that to make sure that you're getting a copy of them. In another video, we talked about how parents can request another meeting or a reevaluation if they believe their child's needs have changed during the year. Progress reports provide good evidence and support if you believe the IEP needs to change. Other portions include a statement of special education and related services, supplementary aids and services, program modifications, or supports for school personnel. There should be a statement about the projected start date, anticipated frequency, location, and duration of these services and modifications as well. And lastly, the IEP needs to include all of the accommodations necessary to measure achievement and performance and why the IEP, why the IEP team chose alternate assessments. All of this is meant to create a really clear picture of what the child needs to be successful in school. If the IEP includes any services or accommodations that take the child out of the general education classroom, there needs to be a statement describing the extent to which they'll be pulled out, as well as a justification as to why. For older children, there needs to be a section that covers transition services too. IDEA specifically states that transition services must be addressed and implemented no later than 16 years of age. If your child is going to turn 16 in the next year, you'll want to make sure these provisions are already included, and remember that the law says no later than, meaning you can start sooner if it's a priority to you and your child. This section clearly has to state measurable post-secondary goals as well, in addition to the transition services that will be required to achieve the goals. If during the year a participating agency fails to provide the services agreed upon, then the IEP team will have to reconvene to determine alternate strategies to meet those goals. In a previous video, we also talked about how with transition services, it includes a lot of community-based activities and real-life experiences to help children with disabilities transition into other roles outside of school once they graduate or age out of school. So sometimes the community agencies, or whether it's a place of work or something like that, sometimes they're not able to fulfill their commitment, in which case the IEP team still has to find a way to help the child meet their goals. Speaking of the IE team, let's quickly talk about who all is considered part of the team. So of course the child themselves is considered a part of the team, though they, excuse me, though they typically won't participate in meetings and planning until they're a bit older. It's at the discretion of the team and the parents ultimately. The parent is a part of the team regardless of the child's age and can give very valuable input on how the child is functioning or what concerns they might be seeing at home that relate to the child's educational needs. The IEP team also includes a regular education teacher if the child is part of general education, in addition to at least one special education teacher, a representative of the school, and somebody who's qualified to interpret instructional implications of the evaluation results. This person could be somebody we've already mentioned, or a related service provider like a physical or occupational therapist. Oftentimes, each person or provider will explain the component of the evaluation and related portion of IEP that they completed, which allows the parent to ask clarifying questions to the most appropriate person and helps to foster that relationship between the parent and each of the service providers. Typically, all team members are required to attend IEP meetings per the law. However, a member may be excused in whole or in part from an IEP meeting if the parent and school agree that their attendance isn't necessary. If their part of the IEP is being modified, they need to submit in writing to the parents as well as the team in writing what their input is. Um, I personally think it's more common for providers just to review their part of the evaluation IEP and then leave if they need to, rather than submitting that written input. But again, remember that IDEA does require their attendance unless you as a parent agree otherwise. So the ball is really in your court in that case. If you're planning on asking something for something specific for your child or for additional services, or you're bringing up a new concern that the team doesn't know about and you want them there, it's okay for you to speak up and say that, and make sure that you have the full team there to listen and collaborate and support. In developing an IEP, the law states that the team must consider the strengths of a child, parental concerns, evaluation results, and academic, developmental, and functional needs of the child. The needs are typically, excuse me, those needs are typically identified through evaluation and input from everybody on the IEP team. IDEA says that the team should consider language and communication needs for children who have vision and auditory impairments, and for those for whom English is not their first language. Another consideration should be the use of positive behavioral intervention and supports. The law states these should be in place if a child's behavior is affecting their own learning or the learning of others around them. And the regular education teacher should have input in these plans. Oftentimes, that teacher is going to be kind of the front lines for implementing the behavioral program or intervention plan. So it's important to get feedback from them about what's going to be realistic and what may work best. And as mentioned, your child's needs might change during the year. If parents in the IEP team agree, they can create a written document in lieu of meeting in person to make adjustments and amendments. However, the law states that IEP needs to be revised and reviewed at least annually. IDEA states that the review should address any lack of expected progress towards the annual goal and in a general education curriculum. The team should also review results of any reevaluations that were done, information that was provided about the child to or by the parents, the child's anticipated needs for the next year, and any other matters that may pertain to their educational success. This is another section where I will be talking about a lot of important parent rights, so feel free to jot some things down or take a screenshot if they pertain to you. Children coming into preschool or kindergarten from early intervention services still kind of go through that same process of an initial evaluation and IEP meeting with the whole team. IDEA states that if a parent wishes, they can request that a service coordinator or another representative from early intervention services be invited to that initial meeting. The people who are evaluating your child really only have contact for a few minutes to a couple of hours, so it can be difficult to really get a full in-depth picture and understanding of your child and their needs. Sometimes it is nice to have that input from the early intervention providers who already know that your child. But don't worry if they can't make it, because remember, there's always the opportunity to make amendments during the year if needed. When developing the initial IEP, the team may consider the IFSP, or Individualized Family Service Plan, that was in place as long as it falls in line with state regulations. The Individualized Family Service Plan is essentially the early intervention version of an IEP. Another important point here is that placement decisions should include the parent. The team may come to the meeting with an idea of where they think would be the best fit for the child's needs, but according to the law, parents have to be included in that final decision. Furthermore, every child with a disability needs to have an IEP in place at the beginning of the school year. Spring tends to kind of be IEP season, so to speak, or a time when a lot of IEPs are either initiated or reviewed, though again, a parent or school can initiate the process at any time if they suspect a child might have a disability. When children with IEPs transfer between schools, They are still entitled to a free and appropriate public education with the services and supports that they need. The new school can choose to either accept the established IEP as is or develop their own by conducting a full evaluation and holding an official IEP meeting. Per IDEA, the new school should request the child's previous IEP and all supporting documents as soon as possible, and the old school is then obligated to respond to that request as soon as possible. The goal is really to provide continuity of services and not allow a lapse, even though there's that transition period. On to procedural safeguards. IDEA Part B requires that state educational agencies, state agencies, and local educational agencies establish and maintain procedural safeguards for parents and children with disabilities. It specifies that these safeguards have to include the following. One, an opportunity for parents to be active participants in meeting, whether it's about the identification, evaluation, educational placement, provision of FAPE, and to obtain an independent educational evaluation. Sometimes parents disagree with evaluation results, in which case they can get a second opinion through a private educational evaluation. Procedural safeguards must also include procedures that protect a child if their parents can't be located with reasonable effort, and to protect children who are wards of the state. The state has to assign a surrogate to make educational decisions on behalf of the child within 30 days of that determination. And it can't be anybody who has a conflict of interest, such as an employee of the school. Furthermore, procedural safeguards require that parents are given prior written notice whenever the school proposes to initiate or change, or refuse to initiate or change, identification, evaluation, or educational placement of a child, or their provision of FAPE. That's basically a long-winded way of saying parents have to be informed before anything regarding their child's education or services is changed. Procedural safeguards should include information for parents on how to access their child's educational records and requirements for parents who choose to place their child in a private school at public expense. Sometimes, excuse me, sometimes despite best efforts, things don't go as expected or planned, and either the school or the parents feel the need to take further action. In that case, procedural safeguards need to include provisions that detail processes to file a complaint, a state level appeal, or civil action, and they should include information on attorney's fees, as well as due process, which we'll talk about here next. Due process starts with either the school or parents filing a complaint. A copy of the complaint has to be given to the opposing party as well as the state agency. IDEA states that it has to include the name of the child in question, their residential address, the name of the school that they attend, the nature of the problem, and a proposed solution if appropriate. Only facts and evidence can be included in this complaint. This is not a place for opinion and assumptions to be expressed, so just keep that in mind if this is ever a road you travel down. Each state is required by law to provide a model to assist parents with filling out their complaints. IDEA further breaks down what needs to be included in a due process complaint. In addition to the proposed action or refusal of action, the complaint should include an explanation of why the agency chooses to or not to take action, and it needs to be supported by a description of the evaluation procedure, assessment, record, or report that the agency used as a basis for that decision. This ensures that neither party is arbitrarily making decisions or claims. Due process complaints need to include a statement that parents of a child with a disability have protection under procedural safeguards and information on the process for obtaining those, as well as sources for parents to obtain assistance in understanding IDEA Part B. The law can be confusing, and in many places, language is not very parent-friendly. So if you run into issues, please be sure to ask the school to connect you with those supports. They should have them readily available. The more you know and understand as a parent, the better you can advocate for your child. Due process complaints need to include a description of other options considered and why the IEP deemed them not to be appropriate, and they should explain any other factors relevant to the agency's proposal or refusal. IDEA states that if a local educational agency, aka a school, hasn't sent prior written notice to a parent regarding the subject matter contained in the due process complaint, the agency has to send a response within 10 days. Similarly to what we talked about earlier, the response needs to include an explanation of why the agency proposed or refused to take a specific action, a description of other options considered by the IEP team, including why they were rejected, a description of the evaluation procedure, assessment, record, or report that the agency used as a basis for their decision, and a description of any other relevant factors. The other party then has 10 days to respond again. According to the law, a hearing officer will determine and inform parties if the notice doesn't meet those requirements. IDEA spells out several instances when procedural safeguards need to be given to parents. This is another document I really encourage you to take the time to review. It has all of your rights and protections as parents. According to the law, the school has to provide a copy at least annually, so oftentimes it'll be um, given along with several other documents in preparation for IEP meetings. The school must also provide a copy when the initial request for an evaluation is made, whether that's by the school or the parent. If at any time either party files a complaint, another copy is going to be provided. And finally, parents can always request it if they lose their copy or just want another one, and they should be able to access it on the school's website at any time as well. So that concludes this portion of my review on IDEA Part B. In this video, we talked about the provisions specifically related to IEPs and covered a lot of parental rights in that process. In the next video, we'll get into the mediation process. Thank you. Have a great day.